I am honored to welcome back to Chautauqua our friend, Jon Q. Barrett. Professor Barrett is the Benjamin N. Cardozo Professor of Law at St. John's University in New York City, where he teaches constitutional law, criminal procedure, and legal history courses. He also is the Elizabeth S. Linney Fellow and a member of the Board of Directors at the Robert H. Jackson Center. Professor Barrett is writing a biography of U.S. Supreme Court Justice and Nuremberg prosecutor Robert H. Jackson. This work will include the first inside account of Justice Jackson's service by appointment of President Truman as the chief prosecutor at Nuremberg of the principal surviving Nazi leaders following World War II. Please help me give a warm Chautauqua welcome back to Jon Q. Barrett.
Thank you so much, Shannon, and President Michael Hill, and Vice President Jordan Steeves, and all of you Chautauquans. This is my 23rd consecutive summer getting to lecture in one venue or another at Chautauqua, which is a very high honor and a special thing in my life. But I do have to say that this venue, the Hall of Philosophy, and this series, the Jackson Lecture, is a particular warm spot in my heart. This annual lecture on the Supreme Court is Chautauqua's lecture in partnership with the Jackson Center. I want to thank Arnie and Jill Bello, whose family fund contributes to the support of this lecture, and thank all of you for being such serious, interested, attentive students of the Supreme Court. That's what makes this work. I have the privilege of introducing 3 topics and then getting out of the way. First is Robert Jackson, second is the lecture, and third is the lecturer. So Robert H. Jackson, born in 1892 in Pennsylvania below the state line, he was a son of Chautauqua. He was one of its greatest products. You see, he moved with his family across the line into New York State and grew up in a little town named Frewsburg. And then after graduating from the Frewsburg High School, matriculated for 1 year as a second senior year of high school in Jamestown, and then he never went to college for a day in his life. At age 18, he began apprenticing with lawyers. He did 1 year at the Albany Law School, and at age 21, he became a lawyer. He was a phenomenon. He was a brilliant person, but he was not well-schooled, except he had, in his region, Chautauqua. And so as a young man, he was first you and me often in the audience, soaking up and learning, and then became a lecturer, and then moved up, as he moved up in life, to bigger and bigger venues, and was connected to the leadership and devoted to Chautauqua for his whole life. He was, in 20 years of private practice in Jamestown, New York, a lawyer who rose from local to statewide to national significance. He was also a Democrat, and he was connected to a state senator who then became Assistant Secretary of the Navy, who then became the governor of New York, who then became the President of the United States, Frank Roosevelt. 10 years older, 28-year-old Roosevelt met 18-year-old Jackson. And at first it was a handshake, but it ripened into a very important relationship and the path to Jackson's greatness. In 1934, Roosevelt nominates and the Senate confirms Jackson to the first of his 5 presidential appointments by President Franklin Roosevelt. He first is general counsel in the Bureau of Internal Revenue in the Treasury Department, today the IRS General Counsel. It was the single biggest law office on earth at the time Jackson headed it. At that time, he headed the prosecution of Andrew W. Mellon, which in 1935, a civil tax case, was the trial of the century. And he had another one a decade later. In 1936, Jackson moved over to the Justice Department. For a year, he headed the tax division. For a year, he headed the antitrust division. He then became the Solicitor General of the United States for 2 years, arguing almost 50 cases in the Supreme Court, and then became Attorney General of the United States for 18 months, 1940 through the summer of 1941. 2 data points in that job progression. In 1937, when Jackson is the Assistant Attorney General heading the Antitrust Division, he didn't just do antitrust. Indeed, he kind of was one of Roosevelt's trusted young lawyers for the situation. And the situation, beginning in February of 1937, was court reform. Court packing by our nickname. And Jackson gave the powerful testimony defending it. The Supreme Court changed path. The legislation proved to be unnecessary. But the echo from then to now is palpable literally today when, almost literally right now, President Biden is in Austin, Texas at the LBJ Library endorsing court reform. A second data point. In the summer of 1940, when Jackson is Attorney General, he is in a law enforcement job, of course, and the Hatch Act existed, but he is a Democrat and it is a presidential election year. So he goes to the Democratic National Convention in Chicago, as the Democrats will convene in a few weeks, and he is one of the leading figures managing that convention, which becomes the draft of Roosevelt to serve a third term. That convention sprawled across numerous hotels, the Blackstone, the Stevens, et cetera, but Chicago was a Jackson place as Attorney General. And then Jackson had a sixth presidential appointment, in addition to those five I've already named. This was a next president, Harry Truman, and this was in 1945, the Nuremberg job. He was America's point man to go to the world stage to bring law and accountability to bear on the Nazis for the aggression of World War II. In his time on the Supreme Court, leaving aside that 1 year when he was actually AWOL from the Supreme Court, Jackson left a mark in our constitutional law. He was a distinctive case-at-a-time jurist. He wrote some huge landmarks that endure: Barnett, the flag salute case, and the rights of conscience of Jehovah's Witness school children. He dissented in Korematsu versus United States regarding the forcible exclusion from the West Coast of Japanese Americans. He wrote a concurring opinion invalidating the claim of presidential power in the Steele seizure case in 1952. And in 1954, just 5 months before his death, he was part of the unanimous 9 who decided Brown versus Board of Education. And then lights out at age 62. So in a sense, term limits by nature, only 12 years on the Supreme Court, more than enough time to leave a very significant mark and make way for the successors. Jackson's legacy includes being the best writer by many accounts in Supreme Court history, a distinctively visible and autobiographical and candid way of thinking, and that thus it's not surprising that Jackson is regularly invoked. He's kind of a cloak that today's Supreme Court justices wrap themselves in because of their admiration for him and, frankly, for the cover that it provides to claim, I'm doing Robert Jackson here. And perhaps we may hear more about that. My second topic is this lecture. As Shannon said, for 20 years, Chautauqua Institution has used its season, which occurs after the Supreme Court term has concluded, and the summer recess of the court and the product of the court that affects us so much, to convene here to really look at it and think about it and discuss it in the classroom of a leading expert. These are great experts, leaders, scholars, teachers, and this year is no exception. Indeed, maybe this year is just the next step upward on this incredible 20-year trajectory. Topic 3, the lecturer this year, is Professor Kate Shaw of the Penn Carey Law School. She is a graduate of Brown University and Northwestern Law School. She was a law clerk to Judge Richard Posner at the U.S. Court of Appeals for the Seventh Circuit, and then she was a law clerk for Justice John Paul Stevens at the U.S. Supreme Court. You heard me say earlier the name Stevens, which is a big hotel, or was then, in Chicago. John Paul Stevens was the grandson who didn't go into the family business. So the Stevens Hotel was run by others, and Robert Jackson and Democrats stayed there when John Paul Stevens was studying law and soon to be in military service and soon to be at Pearl Harbor, and the incredible trajectory that included his exemplary Supreme Court service. Following her clerkship for Justice Stevens, Kate Shaw was an associate counsel in the Obama White House counsel's office. She then became a professor at Cardozo Law School in New York City, and now, since the start of this year, is a professor at Penn. Kate is a great expert in the Supreme Court and constitutional law. Her scholarship is vast and deep and extremely highly regarded. She's also a prolific popular writer, including as a New York Times op-ed contributor, and she is a podcaster. She, with 2 colleagues, are strict scrutiny, which is available wherever you get your podcasts. I think that's the exact phrase, a Crooked Media production. And it is must listen, must view, must study for anyone who cares about the Supreme Court. That's true from law students, through lawyers, through professors, you name it. I would say with just a few exceptions. I'm not sure, for instance, Justice Samuel Alito would say it's must listen podcasting. But it's a classroom that I know that already many of you are in, and so perhaps this complements it. And if you're not, you should show up in that classroom. But in the meantime, you're in this classroom. And so it's my great privilege, really joy, to welcome this year's 20th annual Robert H. Jackson Lecturer on the Supreme Court, Professor Kate Shaw.
All right, well, thank you so much to Jon for that generous introduction. Some of it was true. I'm sure the Jackson stuff was true. But thank you also for your friendship and your warm hospitality while being here. It is a real pleasure to be back at Chautauqua. It's a place I've been lucky enough to visit on a number of occasions. I was here a few times as a child with my parents, my husband, Chris Hayes, who's here in the crowd. Thank you. Gave a wonderful lecture in the amphitheater here about a decade ago. We were here with our then toddler in tow. I had to take her away when she started crying midway through the talk. She's now a formidable 12-year-old, and we've had a couple of kids since. At some point, we should get the whole crew back here. But for now, it is an enormous privilege to be here giving the annual Jackson Lecture. So on to the topic of my lecture today. Less than a month ago, the Supreme Court wrapped one of the most consequential terms in a generation. It issued not one, not two or three, but 4 decisions that fundamentally eroded the power of administrative agencies to protect our health and safety and well-being. It invalidated one of the very few gun safety measures that has been tried at the federal level in recent decades. It temporarily punted on 2 separate questions about the future of abortion access in this country, both for women experiencing pregnancy-related health emergencies and for women wishing to terminate early pregnancies, even in states that protect access to abortion. But it's clear to me that both of those cases, though they were short-term punts, will be back at the Supreme Court in short order. But to my mind, the most important decision of the term, and the one I'm going to spend most of this lecture talking about, was the presidential immunity case, Trump versus United States. In that decision, issued on the last day of the term, the court ensured that former President Donald Trump will not face trial anytime soon, and perhaps will never face trial at all, on most or all of the charges brought by Special Counsel Jack Smith regarding Trump's efforts to remain in office following his loss of the 2020 election. But to me, far more important than the short-term effects of the decision on Donald Trump's legal prospects are the opinion's profoundly dangerous implications for democracy and the rule of law. When Donald Trump first raised the argument that he was absolutely immune from criminal prosecution for everything he did as president, many people, myself included, believed the argument lacked merit to the point of frivolousness. That's what both the district court and a unanimous panel of the DC Circuit held, with the district court explaining that, quote, defendant's 4-year service as commander-in-chief did not bestow on him the divine right of kings to evade the criminal accountability that governs his fellow citizens. No man in this country, not even the former president, is so high that he is above the law. The DC Circuit agreed. But at the beginning of this month, the Supreme Court, after slow-walking the case beginning in December, held for the first time in history that ex-presidents are immune from prosecution for actions they take in their official capacities, even if those actions violate the law. As to some presidential acts, the court announced an absolute immunity. The court explained that this absolute immunity extended to the president's exercise of his core constitutional powers. As to everything outside of the president's, quote, exclusive and preclusive authority, that's important language, I will come back to it, but still within the scope of the president's official duties, the court held that presidents are at least presumptively immune from prosecution, with the burden on a prosecutor to overcome that presumptive immunity by showing that the prosecution would pose, quote, no dangers of intrusion on the authority and functions of the executive branch. This presumptive immunity extended to the outer perimeter of the president's official responsibilities, encompassing everything not manifestly or palpably beyond his authority. And the court held that this presumptive immunity was a minimum. The court did not rule out the possibility that the proper form of immunity for all official acts was absolute rather than presumptive. The court did allow that ex-presidents could be prosecuted for unofficial acts, although this final aspect of the opinion didn't really render it a compromise, since no one, including Trump, was arguing that unofficial acts were immune. The court was also conspicuously silent on what sorts of presidential acts would properly be deemed unofficial, but the signals it sent suggested the list was very short. Chief Justice Roberts' opinion for the court defended this three-part scheme, so absolute immunity for core presidential acts, presumptive immunity for other official acts, no immunity for private or unofficial acts, as largely flowing from another judicial opinion featuring a tripartite scheme, Justice Robert Jackson's famous concurring opinion in the 1952 case Youngstown Sheet and Tube Company versus Sawyer, also known, as John referenced, as the Steele seizure case. Justice Jackson and his famous Youngstown concurrence loom incredibly large in Roberts' majority opinion granting broad immunity from criminal prosecution to ex-presidents. And I'm going to have much more to say about Roberts' reimagining of that concurrence in a few minutes. And I confess I'm a little nervous to be discussing Jackson in the presence of John, who is the scholar of Justice Jackson, along with distinguished attorneys who are Justice Jackson's actual grandchildren. But I will do my best. But let me first say a few more general words about the immunity decision. I will say at the outset, I find it very difficult to defend anything about the opinion. I've already alluded to what I view as its profoundly dangerous core holding, but here I mean the opinion as judicial craft. So whether we're talking about engagement with the Constitution's text, faithfulness to history, compatibility with basic constitutional structure, in which limits on power is a driving principle, or respect for settled understandings of not just courts, but presidents, Congress, and the public throughout our history, the Chief Justice's opinion announcing a sweeping new immunity for ex-presidents fails badly. I'm going to touch briefly on each of these. So first, as to text. It is not just that there is no immunity for presidents or ex-presidents in the Constitution, although I do think that's maybe relevant, but the textual clues that do exist cut directly against the court's conclusion that ex-presidents enjoy sweeping immunity. We know the president can be impeached. The president is the first official listed in the Constitution as subject to impeachment. The Constitution even singles out presidential impeachments as subject to special treatment in that the Chief Justice presides over the trial if it's the president being impeached. The impeachment judgment clause limits the punishment that impeachment can carry to removal and disqualification from future office. But it also adds that impeached individuals are, quote, liable and subject to indictment, trial, judgment, and punishment according to law. That is, an express provision making clear that impeachment does not preclude criminal prosecution. The natural way to read those clauses together is that the president is subject to criminal prosecution, or at least the ex-president is. I suppose we can debate presidents. But if that wasn't enough, consider that Article 1 of the Constitution expressly grants members of Congress immunity for their speech or debate. The lack of any comparable provision granting such immunity to presidents and ex-presidents under ordinary rules of constitutional interpretation would seem to suggest the Constitution should not be read to grant such immunity. Next, consider what founding-era history tells us. Here I'm going to be brief. There's an amicus brief filed in the case by a group of eminent historians, and they put it better than I could, so I'm going to quote them here. Sometimes, they say, history speaks ambiguously, but here it speaks with surpassing clarity. While the founders had a range of ideas about the scope of executive power, none of those ideas included conferring immunity on the president in the circumstances at issue here. The argument to the contrary is not historically credible. Let me give just a couple of examples of relevant statements from key founders. Alexander Hamilton wrote in Federalist 69 that former presidents would be, quote, liable to prosecution and punishment in the ordinary course of the law. He emphasized that while in Great Britain the king was sacred and inviolable, the president, by contrast, would be amenable to personal punishment. James Wilson, perhaps the most important founding-era thinker on the presidency, wrote that federal officers who commit crimes may be tried by their country. If their criminality is established, the law will punish. James Iredell, one of the first Supreme Court justices, explained, quote, "If the president commits a crime, he is punishable by the laws of this country." There's nothing remotely comparable in the historical record pointing in the opposite direction. John warned me about the wind. I'm glad I have these rocks up here. Next, constitutional structure. So the idea of limitation, branches checking one another to avoid excessive accumulations of power, is absolutely foundational. And here I'm going to quote Madison's Federalist 51, which is perhaps the most famous meditation on the separation of powers. And there Madison explains that security against a gradual concentration of the several powers in the same department, that is a branch of government, consists in giving those who administer each department the necessary constitutional means and personal motives to resist encroachments of the others. Ambition must be made to counteract ambition. This is the famous language. The interest of the man must be connected with the constitutional rights of the place. It may be a reflection on human nature that such devices should be necessary to control the abuses of government. What is government itself but the greatest of all reflections of human nature? If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. So at odds with all of that, this decision hands presidents and ex-presidents an enormous new shield and also disables both Congress and the courts from checking presidents and ex-presidents. Okay, then there are the precedents, and that's both court and non-court precedent. So let me start with the court's precedents. So almost exactly 50 years ago, in July of 1974, the Supreme Court rejected another extravagant claim of presidential immunity, Richard Nixon's effort to have the court excuse him from producing White House tapes in conjunction with the special prosecutor's investigation of the Watergate break-in and also cover-up. Just 4 years ago in Trump versus Vance, and that's confusing. It is not running mate Vance, but then Manhattan DA Vance, who was investigating Donald Trump's finances, among other things, and Trump resisted a subpoena from a Manhattan grand jury arguing immunity. And in that decision, in another opinion by John Roberts, the court rejected the argument that Trump should be exempt from this subpoena, quoted John Marshall, noting that while, quote, "a king is born to power and can do no wrong, the president is of the people and subject to law." Even Justice Alito, who would have shielded then sitting President Trump from having to cooperate with this investigation, emphasized that he was talking only about sitting presidents. Alito wrote, this is just 4 years ago, quote, "The law applies equally to all persons, including a person who happens for a period of time to occupy the presidency, claiming only that the nature of the office demands, in some instances, that the application of laws be adjusted at least until the person's term in office ends." So even though those cases involving the president's involvement in criminal process cut sharply and I think decisively against immunity, the court essentially disregarded them. Instead, it purported to rely on two cases, Youngstown, which I will talk about, and the 1982 decision, Nixon versus Fitzgerald, in which the court held that ex-presidents were immune from civil damages suits, that is, from being sued for money by people unhappy with presidential policy. So the court here essentially extended Fitzgerald to announce a new immunity from criminal process, despite the many important differences between civil and criminal processes, and even though Fitzgerald is replete with statements about those differences. Okay, non-judicial precedent. Briefly, there is considerable evidence that previous presidents have understood that they could be prosecuted after leaving office. There's an anecdote in Robert Jackson's book, That Man, which was published after Professor Barrett completed the manuscript that Jackson had begun. And during the early part of FDR's presidential administration, this is just a brief, sort of a detour, but I think an interesting one. The only airport was essentially a pasture that intersected a highway that required closing roads when a plane was going to land or take off. And the president decided the country needed something more than a cow pasture as a national airport, and he wanted to reallocate some funds in order to build one, like a real airport. And he tasked Jackson, who was then the Solicitor General, with figuring out how to free up some funds from other sources for this proposed airport. Jackson found a way to do it. He told FDR how he proposed to move the funds, and FDR asked Jackson whether he was likely to go to jail because of it. Jackson replied that he was willing to go to jail with him if that was any comfort. It's a passing exchange, and I don't want to read too much into it, but I do think it's revealing in that no one thought the president was, by dint of office, categorically exempt from legal exposure. There are other important examples. Richard Nixon never faced any criminal charges for his involvement in Watergate because, following his resignation, President Ford granted him a full, free, and absolute pardon. And the text of Ford's pardon makes clear that but for the pardon, Nixon might have faced criminal prosecution for his conduct while president. Ford wrote in his proclamation that, quote, Richard Nixon has become liable to possible indictment and trial for offenses against the United States, and explained that he was granting the pardon in order to avoid exposing to further punishment and degradation a man who has already paid the unprecedented penalty of relinquishing the highest elective office of the United States. The day before Bill Clinton left office, he reached a deal with Special Prosecutor Robert Ray to pay a $25,000 fine and to agree to a suspension of his law license to avoid criminal prosecution arising out of his testimony regarding Monica Lewinsky. And just 3 years ago, when Mitch McConnell voted to acquit Donald Trump following Trump's impeachment trial for incitement of insurrection, McConnell explained that, quote, we have a criminal justice system in this country, we have civil litigation, and former presidents are not immune from being held accountable by either one. So that's an overview of what the traditional modes and sources of constitutional reasoning would produce on this question of immunity for ex-presidents. But the court in Trump versus United States rejects all of that in favor of a mode of reasoning that was nakedly consequentialist and pragmatic. The court worried about what it would do, like what it would mean for the court not to protect ex-presidents from liability for the crimes they commit in office. The court warned that refusing immunity would result in a chief executive, quote, unable to boldly and fearlessly carry out his duties. The court also reasoned that, quote, the hesitation to execute the duties of this office fearlessly and fairly that might result when a president is making decisions under a pall of potential prosecution raises unique risks to the effective functioning of government. So these passages tell us what is really driving the court in announcing this immunity, concerns about consequences. And to be clear, I am not opposed to judicial pragmatism. I think courts should consider the consequences of their decisions. I think that is at the core of the exercise of judgment. And since I think it's inevitable, I favor being straightforward about it. But what is so difficult to swallow is this court all of a sudden employing this method. Contrast this reasoning with the court's disdain for reasoning from policy or consequences in other spheres. Guns, say, or the liberty and autonomy interests in deciding whether to continue a pregnancy or to marry the partner of one's choice. In cases involving those sorts of questions, the court, or at least some of its members in the current majority, has posited that it is illegitimate to consider the consequences of adopting one reading of the Constitution versus another. Let me give just a couple of examples. When the court in the 2008 case, Heller versus District of Columbia, for the first time declared that the Second Amendment enshrined within the Constitution an individual right to gun ownership, unconnected to the well-regulated militia that is expressly referenced in the Second Amendment, the court rejected the argument that it should consider the impact of its decision in validating DC's handgun ban. Justice Scalia wrote, quote, a constitutional guarantee subject to future judges' assessments of its usefulness is no constitutional guarantee at all. Constitutional rights are enshrined with the scope they were understood to have when the people adopted them, whether or not future legislatures or, yes, even future judges think that scope is too broad. Or here's Justice Thomas in the 2022 Bruin case, which built on Heller and made it significantly more difficult to regulate firearms without violating this court's conception of the Second Amendment. Quote, reliance on history to inform the meaning of constitutional text is, in our view, more legitimate and more administrable than asking judges to make difficult empirical judgments about the costs and benefits of firearms restrictions. Here's Justice Alito making a similar argument in Dobbs, the 2022 case that overruled Roe versus Wade. Quote, in interpreting what is meant by the 14th Amendment's reference to liberty, we must guard against the natural human tendency to confuse what that amendment protects with our own ardent views about the liberty Americans should enjoy. Or another passage, we don't pretend to know how the political system or society will respond to today's decision overruling Roe versus Wade, and even if we could foresee what will happen, we have no authority to let that knowledge influence our decision. I could go on, but you get the gist. The court's current majority has made it a central component of its judicial philosophy to reject and sometimes to disparage reasoning from consequences. But here, when the tools and frameworks the court says should guide it in deciding constitutional cases do not yield the answer it wants to give, it disregards them completely. So I think it's clear the court is here driven by pragmatic concerns about the impact on the presidency of allowing for prosecutions. And to be clear, when I say the justices are driven by pragmatic concerns about the need to protect the presidency, I'm actually not suggesting that for all of them, this is about protecting Donald Trump. I have no reason to believe John Roberts is a fan of Donald Trump personally. I kind of suspect he isn't. He may be genuinely concerned about all presidents and cycles of recrimination, et cetera, but my objections to the opinion extend obviously well beyond its impact on Donald Trump himself. So although the court is driven by its concerns about consequences, and I think that's clear, and several passages as well as the logic of the overall opinion make that clear, the court does not come clean about it. Instead, it claims that its decision announcing this novel form of immunity for ex-presidents is grounded both in broad separation of powers principles and in the court's own precedents. It leans heavily on the civil immunity case I mentioned, Nixon versus Fitzgerald, but the opinion that looms the largest is Justice Jackson's concurrence in Youngstown. Youngstown is, of course, a major presidential power case. It's one that Roberts talked about at length in his confirmation hearing to be Chief Justice. In response to questions about the president, Roberts asserted that, quote, "No one is above the law under our system, and that includes the president. The president is fully bound by the law, the Constitution, and statutes. Now, there often arise issues where there's a conflict between the legislature and the executive over an exercise of executive authority. The framework for analyzing that is in Youngstown, Sheet and Tube." And then he continued, making clear it was the Jackson concurrence that he viewed as the most important. Quote, "My understanding of the appropriate approach in this area is that of the Youngstown analysis, the one set forth in Justice Jackson's concurring opinion." Roberts spoke more broadly about Jackson, actually, during his confirmation hearing. He said, quote, "One reason people admire Justice Jackson so much is that although he had strong views as Attorney General, he recognized when he became a member of the Supreme Court that his job had changed. He was not the president's lawyer. He was not the chief lawyer in the executive branch. He was a justice sitting in review of some of the decisions of the executive, and he took a different perspective. That's, again, one reason many admire him, including myself." Roberts, I should note, is a former law clerk to Chief Justice Rehnquist, who himself clerked for Justice Jackson, and I am sure he is proud to count himself in that lineage. Okay, so Roberts claims to be heavily influenced by this opinion in cases involving the president. So briefly, what was that case about, and what does it actually say? The case was about the lawfulness of an executive order issued by President Truman, ordering the Secretary of Commerce to take control of most of the nation's steel mills and keep them running. The context in which this order was issued was a labor dispute between the nation's largest steel companies and the United Steelworkers. So in June 1950, the US had entered the Korean War, although without a formal congressional declaration of war. And in 1951, a labor dispute arose between the United Steelworkers and the steel companies. Negotiations happened, but then stalled, and the steelworkers announced their intention to strike. Two separate federal agencies tried to resolve the dispute, but none of this worked. And in April of 1952, the union provided notice of its intent to begin a nationwide strike on April 9th. A few hours before the strike was set to begin, President Truman issued his executive order directing the Commerce Secretary to take possession of the steel mills and to keep them running. He actually got on the radio to defend his action. He explained that the national defense imperatives required this. Steel, he said, was critical to most military supplies, right? Things like weapons and tanks, and thus it was critical to the war effort and to the strength of the national economy that the supply of steel remain uninterrupted. The Commerce Secretary then issued orders taking possession of the plants and keeping them operating, and the companies complied, but they immediately filed suit, alleging that the president did not have the legal authority to seize these plants. The administration made a breathtakingly broad argument for presidential power, in particular in emergencies, and the Supreme Court took up the case, framing the question as, quote, whether the seizure order was within the constitutional power of the president. The answer the Supreme Court gave, in a word, was no. Justice Hugo Black authored the majority opinion, and Justice Felix Frankfurter added a concurrence that I like quite a lot. But the most important opinion is, without question, Justice Jackson's concurring opinion. Its enduring power is in part traceable to what Roberts talked about during his confirmation, right? The fact that Jackson himself had served in a number of executive branch roles, including both Solicitor General and Attorney General, and thus he had considerable experience from the perspective of an executive branch lawyer in analyzing questions of executive power. But it is also an opinion that is just bracing, both in its eloquence and the force of its reasoning. So I hope you'll indulge me. I'm going to read a few passages from it as I go. So Jackson's opinion began by acknowledging the relatively small amount of settled law on questions of presidential power. He wrote, quote, "A judge, like an executive advisor, may be surprised at the poverty of really useful and unambiguous authority applicable to concrete problems of executive power as they actually present themselves. Just what our forefathers did envision, or would have envisioned had they foreseen modern conditions, must be divined from materials almost as enigmatic as the dreams Joseph was called upon to interpret for Pharaoh. A century and a half of partisan debate and scholarly speculation yields no net result, but only supplies more or less apt quotations from respected sources on each side of any question. They largely cancel each other." In other words, the text of the Constitution doesn't really answer hard questions about executive power, and statements from the Federalist Papers and other founding era sources can be marshaled to support most positions. So, Jackson continued, quote, "The actual art of governing under our Constitution does not and cannot conform to judicial definitions of the power of any of its branches based on isolated clauses or even single articles torn from context. While the Constitution diffuses power, the better to secure liberty, it also contemplates that practice will integrate the dispersed powers into a workable government." So given these realities, he says, let's try to devise a practical framework for analyzing any president's assertion of authority. And this is where he offers this tripartite scheme that I mentioned a little while ago. So assertions of presidential power, he says, don't happen in a vacuum. They happen against the backdrop of what Congress has done or hasn't done on a particular topic. And they typically come in 3 zones. So zone 1, when the president acts pursuant to express or implied authorization by Congress, his authority is at its maximum, for it includes all that he possesses in his own right, plus all that Congress can delegate. So that's zone 1. Zone 2, when the president acts in the absence of either a congressional grant or denial of authority, he can rely only upon his own independent powers, but there is a zone of twilight in which he and Congress may have concurrent authority, or in which its distribution is uncertain. In this area, any actual test of power is likely to depend on the imperatives of events and contemporary imponderables rather than on abstract theories of law. And then third, when the president takes measures incompatible with the express or implied will of Congress, his power is at its lowest ebb. Okay, so 3 categories. Congress gives some power to the president acts pursuant to it, the president usually acts lawfully. Middle category, a little less clear, courts have to figure it out. And a third, Congress wishes to deny the president some authority, the president's power is at its lowest ebb. So in Youngstown itself, Jackson concludes that the asserted power fell within Zone 3 because Congress had taken actions that clearly communicated its desire to deny to the president the power to seize property like these steel mills in the event of a labor dispute. So the president's seizure was unlawful. So that's Youngstown, and in particular, Jackson's opinion in Youngstown. And for decades, it has stood as a declaration of both judicial independence and also the limits on presidential power. Many, many judges have pointed to Jackson in Youngstown as the North Star in cases involving executive power. And this case is no exception, right? Youngstown is the first Supreme Court case Chief Justice Roberts cited in his majority opinion in Trump versus United States, and he cited it in total 10 times, most of those cites to the Jackson concurrence. In opening the opinion, Roberts noted that, quote, "This case is the first criminal prosecution in our nation's history of a former president for actions taken during his presidency. We are called upon to consider whether and under what circumstances such a prosecution may proceed. We undertake that responsibility, conscious that we focus on," and here he's quoting Youngstown, "the enduring consequences upon the balanced power structure of our republic." But Roberts didn't simply take broad inspiration from Jackson and Youngstown. He suggested that Youngstown supported a finding of presidential immunity, including some absolute presidential immunity, through the novel 3-part immunity framework that I referenced a little earlier. So in the first of the categories, in Roberts' 3-part scheme, the president is absolutely immune when exercising core Article II powers. This category, says Roberts, flows directly from Youngstown, and in particular, Jackson's Zone 3. The Roberts opinion explained that in constitutional cases, the president's authority is sometimes, quote, conclusive and preclusive. So like he's got it, and it precludes anyone else from trying to regulate or check it. According to Roberts' gloss on Jackson, when the president exercises such authority, meaning this core Article II authority, he may act even when the measures he takes are incompatible with the expressed or implied will of Congress. The exclusive constitutional authority of the president, he says, disables the Congress from acting upon the subject. Once it is determined that the president acted within the scope of his exclusive authority, his discretion in exercising such authority cannot be subject to further judicial examination. So you might think from reading this Roberts passage that Jackson's opinion contained a full-throated endorsement of broad presidential powers beyond the reach of Congress to regulate or courts to examine. But the very passage Roberts is quoting snippets from, when read in its entirety, conveys an entirely different message. It says of this Zone 3, where the president acts contrary to congressional will, quote, I said already this, when the president takes these measures, contrary to the will of Congress, his power is at its lowest ebb. And then he continues, courts can sustain exclusive presidential control in such a case only by disabling the Congress from acting upon the subject. Presidential claim to a power at once so conclusive and preclusive must be scrutinized with caution, for what is at stake is the equilibrium established by our constitutional system. So rather than announce this conclusive and preclusive power, the passage is really warning about the danger. It is suggesting the paramount need for caution in recognizing it. It suggests that presidents may rarely act contrary to congressional discretion, and it certainly, congressional direction, and it certainly doesn't bless Truman's defiance of Congress in the seizure context. Roberts flips the valence of this passage entirely. Here's where else in his concurrence Jackson warned of the dangers of unchecked and concentrated executive power, in particular of the emergency powers the administration was claiming the president had the power to assert. Quote, the example of such unlimited executive power that must have most impressed the forefathers was the prerogative exercised by George III, and the description of its evils in the Declaration of Independence leads me to doubt that they were creating their new executive in his image. Continental European examples were no more appealing, and if we seek instruction from our own times, we can match it only from the executive powers in those governments we disparagingly describe as totalitarian. Here's what else Jackson had to say. I cannot be brought to believe that this country will suffer if the court refuses to further to aggrandize the presidential office, already so potent and so relatively immune from judicial review. These aspects of Jackson's concurrence are not only absent from, but run directly contrary to Roberts' opinion. And that's, I think, made even clearer in the context of two examples that Roberts discusses, one involving the president's relationship with the Department of Justice and one involving presidential speech. I'll just briefly touch on both of them. So the majority suggests that the president's relationship with the Justice Department is in the category of presidential powers that Congress cannot regulate, including by exposing a former president to criminal liability under generally applicable laws if he violates those laws in his dealings with the Department of Justice. I think this is an exceedingly dangerous position. I can't imagine it's one Justice Jackson would have endorsed. According to Roberts, allegations that the former president tried to use DOJ to further a scheme to remain in office, quote, plainly implicate Trump's conclusive and preclusive authority. Roberts explains that's because investigative and prosecutorial decision-making is the special province of the executive branch, and the Constitution vests the entirety of the executive power in the president. So that means that we are in Roberts' first category, so, quote, Trump is absolutely immune from prosecution for the alleged conduct involving his discussions with Justice Department officials. Again, what this means is no matter how a president interacts with his subordinate officials at DOJ, or why, he can never be prosecuted under generally applicable laws, potentially, according to dissents by Justice Sotomayor and the current Justice Jackson, Ketanji Brown Jackson, by plotting a coup, directing subordinate officials to commit treason, perhaps even murdering them. Those all involve interactions with DOJ. This is in Ketanji Brown Jackson's opinion. And on the logic of the majority opinion, all of this would be immune. The relationship between the president and the Department of Justice is a complex one, as anyone who has ever served in the White House or the Department of Justice knows well. John Roberts knows this too. But to suggest that the court can eliminate all of that nuance and complexity in favor of an absolute presidential prerogative vis-a-vis DOJ and to claim it flows from Youngstown is, I think, madness. And in a part of the opinion I haven't yet mentioned, the court holds that even if a prosecutor manages to make out a case based on unofficial conduct, this conduct within this category of absolute immunity can't even be introduced for its evidentiary value. No reference could be made to interactions with DOJ, even in, say, a bribery prosecution for unofficial conduct, because that's how powerful this absolute immunity is. One more example, presidential speech. So Roberts applies his framework to a couple of other aspects of Jack Smith's complaint, and the one I want to quickly talk about here is the aspects of the indictment that describe Trump's tweets encouraging supporters to travel to DC on January 6th, and then his speech at the Ellipse on January 6th. This kind of speech, Roberts explained, was not absolutely immune, like the dealings with DOJ, but was presumptively immune. So here's Roberts, quote, "The president possesses extraordinary power to speak to his fellow citizens. A long recognized aspect of presidential power is using the office's bully pulpit to persuade Americans. For these reasons, most of a president's public communications are likely to fall comfortably within the outer perimeter of his official responsibilities." Now, I think it's clearly right that for over a century, presidents have used the bully pulpit to augment the formal powers of the presidency. For Roberts, that's a reason to give presidential speech at least presumptive immunity from criminal prosecution, no matter how dangerous or destructive the speech. But here's what Jackson had to say in language that is shockingly relevant even 70 years later. Quote, "Executive power has the advantage of concentration in a single head, in whose choice the whole nation has a part, making him the focus of public hopes and expectations. In drama, magnitude, and finality, his decisions so far overshadow any others that almost alone he fills the public eye and ear. No other personality in public life can begin to compete with him in access to the public mind through modern methods of communication. By his prestige as head of state and his influence upon public opinion, he exerts a leverage upon those who are supposed to check and balance his power, which often cancels their effectiveness." So to Jackson, the fact of the president's access to communication channels, to the bully pulpit, was reason to constrain executive power. Roberts, in his immunity decision, turns that logic on its head, suggesting that the president's rhetorical primacy is a reason to insulate the president from sanction for illegal acts that may involve speech. Roberts ends his immunity decision by invoking the separation of powers. Quote, "The system of separated powers designed by the framers has always demanded an energetic, independent executive. But by eliminating an important set of checks on the president, the opinion subverts the separation of powers. The opinion purports to rely on Jackson's Youngstown concurrence, but it fundamentally betrays it. The opinion creates a permission structure for lawlessness." So let me just end with one more Jackson quote, and then I'll say, and then two more concluding words, sorry, and I do want to leave time for questions. Okay, so Jackson says, quote, "With all its defects, delays, and inconveniences, men have discovered no technique for long preserving free government except that the executive be under the law and that the law be made by parliamentary deliberations," right, the legislature. "Such institutions may be destined to pass away, but it is the duty of the court to be last, not first, to give them up." So I'm not by nature alarmist, but I think this opinion displays a court acting fundamentally at odds with core constitutional values, but the court is just one institution. Its betrayal of those core values only heightens the urgency of the rest of our institutions safeguarding them. The opinion does not have to be the last word on these questions. So I mentioned how misguided I think the court's discussion of the relationship between the president and DOJ is. It's clear that under this opinion, presidents will not face judicial accountability even for violations of law that involve DOJ, but that does not mean that attorneys inside DOJ shed their own obligations to abide by the Constitution, something they take an oath to do, whatever this opinion says. And I'm actually heartened by President Biden's op-ed this morning about Supreme Court reform, in which he endorsed not only term limits, but a binding ethics code, but a constitutional amendment to reverse this misguided decision. Now, we should be clear-eyed. The Constitution's amendment process, Article 5, is an arduous one. It requires supermajorities in both houses of Congress and among ratifying states, but it was designed to give the people's elected representatives the lead role in shaping constitutional meaning, especially at times when the Supreme Court and its interpretations of the Constitution neglect the needs and desires of the American people and undermine meaningful self-governance. It has happened before. The 14th Amendment itself, perhaps the single most important part of the Constitution, was a direct response to the Supreme Court's disastrous 1857 decision in Dred Scott versus Sanford. The court does not always need to be the final word on the meaning of our Constitution. We, the people, can be. And with that, I'll wrap. Thank you so much, and I'm happy to take some questions.
As we move to audience Q&A, we know some of you use this opportunity to move to other programs, and we just ask that you please do so quietly out of respect for your fellow audience members and our speaker. My name is Karen Chavone, and I am proud to serve Chautauqua Institution as Associate General Counsel, and I am stepping in to moderate our Q&A today. As a reminder, there are 2 ways to submit questions. Our ushers are circulating with paper and pencil, and you can also submit through our questions portal at questions.chq.org. So, Kate, we've already gotten several questions in, and a strong theme here seems to be the extent to which the court might abuse their power by ignoring the Constitution or depending on how they interpret the Constitution, but really kind of taking things into their own hands. And people are just wondering if you can comment on why they're choosing to ignore precedent and the Constitution and do their own thing.
Yeah, I mean, I think that sort of hubris, a lack of humility, those are, I think, the best, most accurate descriptors of this Supreme Court at this moment in time. Of course, the court will interpret the Constitution, and some of us will disagree about the interpretations that the court reaches. But what I haven't seen in my lifetime, and I don't think we've seen much in the history of at least the modern era, is a court so willing to disregard settled understandings, its own precedents. You know, it's not just about overruling cases. Dobbs is a huge deal because it overrules a really important precedent that was reaffirmed multiple times and because its stakes are so palpable for so many people. But Dobbs is not the only wildly disruptive opinion that the court has handed down in the last few terms, and in some ways that's, I think, why it's useful to focus on, executive branch precedent and other settled expectations, because some of the things the court is deciding are actually, or at least considering, and in some cases deciding, are so outlandish, it doesn't have to overrule any cases to decide in favor of some of these requests, because no one has ever asked before. That's how audacious they are. I mean, one of the administrative law cases I mentioned at the outset essentially upends decades at least, depending on the agency, of practice in terms of how agencies resolve adjudications. And that's a major method of agency enforcement of the laws. And the court just decided, well, nobody's noticed for all the time that agencies have been doing their work that the 7th Amendment of the Constitution requires a jury for all of these matters. Or in the big case overruling Chevron, which is something else I thought about talking about today, that's the Loper-Bright case, the court both overrules this 40-year-old precedent, but also says, oh, and no one has ever noticed that this rule set forth in the Chevron case violates the Administrative Procedure Act, a law from the 1940s that judges, smart judges for decades have been aware of, and yet this court is willing to basically say, we and we alone can sort of see what the Constitution and the laws mean, and that, I think, is a very dangerous place to be. Now, I don't know that I can speculate about why we are there, but hopefully that's, I'm happy to, but hopefully that's a little bit of an answer of what exactly is happening right now that is so different from what we've seen before.
Thank you. We have a couple questions here about asking, what can we do as citizens? What can we do? What can the current administration do to sort of close the door on unlimited immunity for presidents going forward?
Look, I think that there are a couple of things. One is the reason that Biden proposes amending the Constitution is because when the Supreme Court issues a constitutional decision, the only ways around it are the court overrules its decision. The court can narrow it, or a constitutional amendment overrides it. And so I actually think there's something very, very healthy about starting a conversation about formal constitutional amendment, right? We haven't amended the Constitution since 1992. It was kind of a small potatoes amendment then about congressional salaries. We've, for many decades now, lost I've referred to this in writing before as like lost the muscle memory of constitutional amendment. I think it's wildly unhealthy to have a Supreme Court that is this powerful, issuing sweeping decisions that affect all of us, with an amendment process that is functionally out of reach, right? That is not a healthy recipe for democracy. And so I do think that actually having real debates about the possibility of constitutional amendment is critically important. But I also think that presidents, the bully pulpit that I talked about at the end of the talk, is powerful. Like, genuinely, Jackson is right about that. It's an incredibly powerful tool that presidents have. So I think that obviously Biden isn't seeking re-election, so he has a limited amount of time on the clock. If he wants to make telling Americans that what is happening right now with the Supreme Court is wildly anomalous and fundamentally incompatible with the role of a court in a democracy, I think that's a very constructive use of political capital and time on the clock. And I think for future presidents as well. So I do think that we haven't paid enough attention to the Supreme Court, and I think that that is starting to change, and I think it's valuable that it is. So that's not a magic recipe for how to change, but I do think the court claims that it doesn't pay any heed to public opinion, and often the historical records suggest that sustained enough public objection and resistance to what the court is doing does have an impact on the justices. So I think kind of paying attention, staying focused on it, understanding the court as a major ballot issue. You're voting when you vote for your senators and for president for what the Supreme Court will look like in 5 or 10 or 20 years. And I think that all of those changes, I think, are sort of what we need to look at. And maybe the last thing I'll say is this is a very entrenched conservative supermajority on this court, and changing what the court looks like may be possible in the margins if the public pushes back hard enough, but really changing the composition of the court will be a decades-long affair. And so I just think patience, hydration, understand that you have to be in it for the long haul, and there's not going to be change overnight, but that's not a reason to despair because change remains possible.
We have a couple questions here about Chief Justice Roberts and how he will be judged throughout history. If you could comment on that.
I mean, I think my answer is different after this term, honestly. I do. I mean, I think that it's which John Roberts is, I think, the hard question. I do think that there have been a few different iterations of John Roberts, and I don't think he wrote an opinion, and I said this and sincerely, I don't think he wrote an opinion trying to protect Donald Trump, the person, the presidential candidate. I wouldn't rule out the possibility that others in the majority had that view, but I don't think that he likely did. I don't know. But I don't know why he seems to have so abandoned institutionalism, because that's how it feels. It really feels like he has, and I think he did care, unevenly, but sincerely about the court as an institution, about checking executive overreach. There were two really important opinions in the Trump administration involving a question about citizenship on the census and about rescinding the DACA program, the Deferred Action for Childhood Arrivals, where he cast the decisive vote to invalidate these Trump administration initiatives. And I just have a hard time believing he would write those opinions today. So I think that, which John Roberts is the question, and I think he'll be the chief for a while yet, and so I don't know that we quite know in the final analysis which of these John Roberts will loom the largest, but in just the last couple of years since the 6-3 conservative supermajority has been cemented, I have a very hard time seeing John Roberts, the institutionalist, and John Roberts, the statesman, and I don't think if the record closes here, I think it's very hard to see that being the kind of top line of, our sort of the historical records, the John Roberts entry in the book of history.
This audience member asks, if Trump is reelected, he could pack the court even more. Are there any things we could do under those conditions?
Well, there is vote. That's, if he is reelected, look, I think we don't know exactly what resignations or vacancies will arise. I think the most likely vacancies are, retirements by Justice Thomas and Justice Alito. I think they're quite likely to leave under a Trump administration. Well, yes, but consider the replacements. And so that's, I think that wouldn't fundamentally alter the balance in votes on this court, but it would lock up, conservative control of those seats, I think, for many, many decades, because I think Trump would very likely install equally hardline conservatives and much, much younger than Thomas and Alito. And then if there were another vacancy, I mean, right now it's a 6-3 conservative supermajority that can very, very occasionally flip 2 votes and prevail in narrow ways. John Roberts, notwithstanding what I just said, has occasionally crossed over to vote with the 3 Democratic appointees. And when that happens, you need to peel off Brett Kavanaugh or Amy Coney Barrett or very occasionally Neil Gorsuch. And in a 7-2 conservative court, that's just never going to happen. And so I do think that another vacancy that's on the left as opposed to the right side of the court would mean change, in any of our lifetimes is almost impossible to envision. So, I mean, I guess I just come back to what I said before, which is that the stakes of this upcoming election are extraordinarily high.
Could you comment on the ethical standards of the Supreme Court?
Such as they are. I mean, we when the court issued last fall its new code of conduct, my podcast host and I refer to it as a code of misconduct, because I do think that the fact that they saw fit to actually put into writing for the first time something that called itself a code of conduct, non-binding, pretty weak in really important respects, but something, was actually an example of something I said a couple of minutes ago, which is the court does sometimes respond to public opinion. It was the extremely hardworking investigative journalism that we saw that really, revealed so much very, very dubious conduct by some of the members of the Supreme Court in terms of their acceptance of largesse by billionaire benefactors. And the court, they have filed updated financial disclosure reports, not admitting wrongdoing, but conceding that they had taken trips they hadn't reported and were going to start reporting them. And I think all of that does matter, but I think that Biden is right in this, announcement today. It's way, way, way too little. There needs to be a binding, code of conduct that Congress passes a statute, has some kind of meaningful enforcement mechanism. They probably shouldn't be able to take gifts at all, apart from, family members. And there is some murkiness always about what, friends, where the category is around friends and individuals who are just seeking to have sway. But some of these, benefactors or individuals with whom Justice Thomas at least didn't have, and Alito as well, a pre-existing relationship prior to taking the bench. It's very hard to see how that's a pre-existing friendship that should be exempt from whatever ethics regime is in place. But I think we need much more, and I also think this is an issue that it should be possible to galvanize, broad bipartisan support for. Corruption is not super popular, and this looks very corrupt. So simply framing this as an anti-corruption measure, I think, if done well, I think could actually be something that was able to command broad public support in ways that some of the substantive issues the court decides sometimes can't or don't. But I think that Biden is right to focus on this, and I think it could be both a substantively important change and maybe even good politics. I'm not an expert on that last part, but it seems like it could be.
Okay. I'm going to do my best to combine 2 questions here. This person writes, as an observer of the court and its members, do you think the court is influenced by the public's concerns about its legitimacy? And the second person asks, do the justices encourage or require groupthink or peer pressure?
Well, I think I'll say again, yes, I think they do care about public perception. I mean, it's not always clear what we mean by legitimacy, right? There's a few different ways we might be using the term. But I do think that the justices care. I think there was polling in March or April that suggested that 80% of members of the public thought that before the court had decided or even heard but had taken the immunity case, 80% of these survey respondents thought, no, ex-president should not be immune from any criminal prosecution. That's a big, it's hard to get 80% of Americans to agree on most questions. And so that was, I thought, a really revealing and important survey result. What I don't think has been polled yet, I sent a note about this morning, and no one can find anything. I don't think anyone has polled that question since the decision. But an 80 or 90% consensus against something the Supreme Court has said, I think that can start to matter, but it is what we make of it. So if kind of intermediaries, if elected politicians, if individuals and coming to talks and giving talks actually focus on all of this, I think it actually could matter. How much? Will it cause them to pull back a little bit on the maximalism? Maybe. It won't probably fundamentally change what a lot of these justices are going to do, but I think on the margins it could make some difference. I'm not sure about whether the groupthink question is about the justices or about us. Could you tell from the, I think they're in some ways like the conservative justices they all actually think pretty differently in certain respects. They're all lined up in outcomes in most cases, but they think somewhat differently in terms of reasoning. There are a couple of cases this term that feature, a separate concurrence by each conservative justice. So I'm not sure, but I think they are in general sort of signed on to a program with a bunch of precepts, which is maximize presidential power, reduce the power of independent agencies, maximize judicial power, narrowly read provisions of the Constitution guaranteeing things like liberty and equality. But beyond that, I'm not sure. I wouldn't say groupthink is really how I would describe the way they think. Yeah.
A couple questions here about this topic. Do you think the new state policies to require prayer and/or 10 commandments posted in public schools are intentionally designed to make their way to the Supreme Court? Are we relitigating separation of church and state?
Yeah. Yes. I think that the one major hot button issue we didn't see much of this last term was religious liberty. And I think we probably will in the coming terms. But the separation of church and state, the question has, a premise that remains a viable, enforceable constitutional value. And I think a majority of the Supreme Court thinks that's not even something the Constitution requires. The court has essentially read out of the First Amendment the Establishment Clause, which was once understood to really place a limit on government's ability, under the Constitution to support or endorse religion. And the court has basically said the important value in the Constitution with respect to religious liberty is its protection of the exercise of religion, not its limitation on government endorsement of religion. So I think that absolutely there are a number of test cases in the pipeline, in which actors in state legislatures and state executives can read Supreme Court precedent, and they're absolutely right to make a prediction that long-standing Supreme Court cases doing things like limiting prayer in public schools are totally vulnerable under the court's recent religion cases. And it's just a matter, to my mind, of how many steps, whether the court will just do some outright overruling or, do something it did to an important religious liberty case or Establishment Clause case called Lemon. It didn't say we're overruling, it said we are recognizing that we already abandoned it. So it didn't, get a tick mark in the kind of how many cases overruled category, but that was a really important precedent that it repudiated. So I can see the court potentially endorsing some of those once unthinkable practices like, the installation of 10 commandments in public spaces and the mandating of prayer in public schools.
This question asks, how devastating or impactful is the Chevron decision?
I think 10 out of 10, honestly. I presume that means the Loper-Bright decision overruling Chevron. I think it's enormous. I think it depends somewhat on the agency, and I think that there are some statutes that might still give agencies the discretion to interpret statutes, and so the court tries in a few places to suggest that it's cabined, like it's the impact of its ruling. But I think it fundamentally unsettles the way agencies have understood their ability to work with the statutes passed by Congress. Congress has long legislated in pretty broad terms because it can't envision every potential eventuality. In particular, if we're talking about, workplace hazards or environmental hazards, right? Agencies have broad delegated power to act to protect things like health and safety, and those delegations involve broad language. And under Chevron, it was agencies that got to decide what that broad language actually meant, and it is now courts, and the Supreme Court in particular, that will decide that. And I think given the very deregulatory bent of this Supreme Court, it is likely to interpret all ambiguous provisions in statutes to cut against as opposed to confer power on agencies.
Based on your own experience as a clerk, can you talk about the dynamic within the court? It was said that William Brennan could persuade fellow members like a politician. Is there any of that occurring now?
Look, I don't really know. I don't have inside sources who tell me what things are like on the Supreme Court. I got to imagine that Justice Kagan is sometimes effective at persuading her colleagues. She's the only one on that court who I can imagine really being effective in that regard. But I don't know. I mean, I think that I clerked on the court when it was, there was still Justice Kennedy was a swing justice, and there was a lot of active persuasion, mostly in writing. Like, it wasn't a lot of in-person communication, but it was a lot of memos would fly back and forth trying to, justices trying to persuade one another. And my general impression is that the camps are much more hardened today than 15, 20 years ago. And so I'm not sure there is anyone who is, you at some point, like, I imagine futility, will disincentivize trying to sort of serve that function if you know your colleagues are fundamentally unpersuadable. I hope that it still happens some of the time.
We have a couple questions about jarcossy. How in 2024 are we looking to 18th century common law for guidance? Civil rights, human rights, and employee rights hardly existed at that time. So are all of those categories of cases exempt from jarcossy?
So jarcossy is the case that I mentioned that finds that agency and the SEC's enforcement procedures, which involved bringing enforcement actions in front of an administrative law judge, are unconstitutional because you have to go before a civil jury under the 7th Amendment to bring those actions. I think it's right that there's just a fundamental mismatch between this 18th and 19th century common law history the court says it is going to be guided by in resolving all manner of constitutional cases, and the reality of the way administrative agencies enforce the law. I think it's maybe that would be, I think, a great outcome if the court had to say, well, there weren't any kinds of enforcement actions, agencies didn't do anything involving things like civil rights, and so we're not going to be yoked to this limited and exclusionary history in deciding what agencies have the power to do in those spheres. There's more of a common law analog with this securities fraud and common law fraud. So maybe, but it just feels to me like the court will just generalize up or down in terms of levels of abstraction in order to disempower agencies. So it will remain focused on history and just play a little fast and loose with what history and at what level of generality the history really matters. So yeah, I think jarcossy, not as kind of seismic as Loper-Bright in terms of the administrative law cases, but I think it's a hugely impactful case in terms of impeding agency enforcement.
Our last question. If you could wave a wand and make court reform happen, what would you prioritize?
Oh, this is so hard. Court reform happen. I mean, I guess I think that at this point, I was court expansion, right? Sometimes referred to as court packing. Court expansion is something I've long thought was really, I was a little bit squeamish about it, and I think I've kind of come around to this court is going to be an enormous obstacle to implementing popular will for the foreseeable future. And I actually think if you had a president and a Congress that just could, by statute, add a bunch of additional seats to the Supreme Court, I think I've come around to the conclusion that that's what should be pursued. So yeah, there's my wand.
Chautauqua, please join me in thanking Professor Kate Shaw, John Barrett, and the Robert Jackson Center.